So thank you so much for hosting this excellent event. I really enjoyed this morning's session. I'm really sorry that I can't be there in person because it's always so great to have the little lunchtime and coffee time chats, but it's still good to be able to join online. So yeah, as the brief bio there indicates, my background is more transitional justice than climate. I've traditionally been interested in legal responses to mass atrocity crimes. So with a focus on international criminal law and other transitional justice measures. But as I've become, as we all have, more and more concerned about the various crises facing our world, it has struck me how many similarities there are between the challenges facing responses to atrocity crimes and the challenges facing responses to climate harms. So the premise of my presentation is that the climate reparation debate can be usefully informed by the lessons already learned in the field of transitional justice. So although its TJ has historically been oriented around other types of violence, war crimes, and genocide, and things like that, it has established networks and frameworks for addressing large-scale harm in politically sensitive contexts. And also, it shares some of the challenges, as I said, particularly surrounding designing victim-centered remedies, facilitating restorative alongside transformative justice measures, the challenge of accountability, and the broader problem that it is entirely impossible and also completely necessary to redress the harm being discussed. So I think transitional justice can be interesting because while the UNFCCC and the Loss and Damage Fund debates often center around what states owe to each other, which is obviously an extremely important part of the discussion, adopting a transitional justice lens focuses the eye more on the rights of victimized communities, so individuals, communities, and as I'll talk about today, other than living beings who can be left out of policy debates, but who are bearing the brunt of the climate crisis's violent impacts. And so I'm not the first to raise those similarities. There's a growing scholarship that looks at how to adapt transitional justice approaches to climate justice. As my colleague Jasmina Brankovic has noted, this is because the field contains over 3 decades worth of experience. And so given the scale and gravity of the crisis, we need to learn wherever we can and from wherever lessons might be learned. So what I want to do today is draw on that scholarship as well as the broader TJ scholarship to look in particular at victims' rights in the context of climate reparation. So I want to briefly look at lessons from TJ concerning procedural and substantive justice and repair. And then I want to highlight 2 areas where there's innovation or potential innovation within TJ scholarship at the moment that might be particularly interesting for climate reparations conversations. So the first is the growing recognition of other than human victimhood, and I'll focus in particular on the Colombian case study, and then also the debates around whether we need a new atrocity crime in the form of ecocide, and whether individual liability has a place in a climate reparations discussion. So to turn first from these broader lessons from TJ practice, as many in the room will know, one of the fundamental pillars of TJ is the recognition of victims' rights. This is informed by the UN Basic Principles and Guidelines on the Right to Remedy and Reparation, which outlines a variety of key victim-centered principles. Because of the growing links between the climate crisis and a whole range of serious human rights violations, and because of the growing use of human rights-oriented climate litigation, I think this framework is likely to gain more and more relevance as the harms of the climate crisis become more and more acute. And so TJ has expanded on these procedural aspects that are found in the UN Basic Principles and really emphasized the importance of participatory approaches. This has a variety of different benefits when you involve victims, those who are bearing the brunt of harm. It increases a sense of symbolic recognition. So it has, involving victims just has benefits in its own right. It can contribute to a greater sense of justice for those involved. And so a lot of my work has been in the Cambodian context, where the Khmer Rouge Tribunal has involved victims. And for those that were able to participate as civil parties, there was a sense of historical acknowledgement that came via that participation. But of course, beyond that, participation is about ensuring appropriate outcomes. We need to ensure that victims' voices are heard in debates about reparation, because the absence of their voices obviously leads to a greater chance that reparations are going to not fully recognize the range of harms that they experience. And then in contrast, the more successful examples of reparations that we find in TJ tend to have some role for victims in their design, development, and delivery. That links to my third point, which is we need to ensure victims' voices are front and center because of the legitimacy and transparency of the process. So if victims are able to participate, they're more likely to understand a measure, a transitional justice or a climate reparation measure as being legitimate. I think this is really critical in the climate context because the debates are often progressing on the assumption that states can adequately represent the wishes of victimized communities. But that completely overlooks the reality of state violence against its own societies, as well as the fact that many of those communities within a state, whether that's an indigenous community on a small island state, whether that's a climate refugee, whether it's traditionally excluded populations like women and children and minorities, this assumption that we can have a conversation about climate reparations at a state level risks overlooking the need for victim voice and the diversity of voice. Furthermore, research with victimized communities suggests that if you do involve them and make them feel part of processes, then that can enhance the experience of justice, even if the ultimate outcome can't fully address all of their needs. So that can enhance legitimacy that way as well. Now, of course, victim participation in any justice measure is never straightforward, and that's particularly the case in TJ, where we're often talking about thousands of people who have been harmed. So that challenge around scale is obviously applicable to the climate context, where we might be discussing millions of individual beings who have suffered harm. So there's lessons to be drawn from TJ regarding how do you manage a large collective. And so again, in the Cambodian context, we're only talking about, we're only talking about tens of thousands of beings. But what we saw in the transitional justice process was that shift towards collective participation, collective representation models, so that victims who share experiences or perspectives can speak through a shared representative. So that obviously involves compromise, it dilutes the individual sense of engagement, but it introduces a pragmatic perspective to enable some form of participation in the face of extreme harm. Within any large group, there's going to be hierarchy. So again, that comes back to the point about who is getting a chance to speak. And this was also raised this morning as well, both in the presentations and the discussion. So transitional justice is rife with examples of victim hierarchies and presents examples of both good and bad practice that can be learned from in ensuring folks have the potential to make themselves heard. And I want to acknowledge Zoe and Julia's work in exploring the possibilities of participation in their Anthropocene judgment, where they kind of talked about modalities of reparation, but then decided at the end not to offer a full solution, but instead to establish a democratic participatory process. So there's scholarship already exploring how we might do this in practice in a climate context. A relatable challenge concern is equitable access to justice for those who face socioeconomic barriers. Again, this follows on from the discussion this morning around the Global South, but again, can play out within states as well as across different states. Transitional justice scholarship, I think, is helpful in highlighting the central role of civil society in bridging gaps and ensuring that when you have robust civil society involvement, there's a greater chance that different voices are going to be heard, and that this can be particularly important when we're engaging with large numbers of victims. So turning to substantive justice and repair, the UN Basic Principles framework that I mentioned and transitional justice practice establishes the role of reparation beyond just compensation. So obviously, again, at a state level, there is a need for significant financial compensation for the loss that has been incurred by the disproportionate causing of the climate crisis. But TJ also highlights that when you only give money and you do not provides symbolic recognition, acknowledgement, apologies, those kinds of things, this can still feel hollow to those that are bearing the brunt of the harm. And so I think there's examples to be drawn from, for example, the Inter-American Court of Human Rights, who've ordered states to restore Indigenous land and implement community development initiatives as part of reparations for environmental and human rights abuses. I think there's some clear lessons to be learned for the climate context. And to return to obviously my pet love, Cambodia, where reparations have included public acknowledgement and memorialization alongside other forms of repair. So this really shows that we need to attend to the different types of harm and also think about how to balance both backward and forward facing repair. So transitional justice's more recent scholarship is really centered around the potential role for guarantees of non-recurrence and systemic reform, particularly in the kind of transformative justice space. And there's a significant amount of work exploring how do you deliver reparations that are not just about addressing past harm, but also ensuring injustice does not happen again. Again, building on what was discussed this morning, we can find examples in TJ context where there's legal or institutional reform, like constitutional amendments, human rights protections, policy changes, those kinds of things enacted to prevent the recurrence of violence. With climate reparations, the scale is once again larger in terms of the structural changes required because we're up against capitalism. But initiatives like stronger environmental regulation, shifts towards renewable energy, the protection of Indigenous land rights, of course, all present possibilities for guarantees of non-recurrence. TJ also emphasizes, again, that idea of balance. So yes, we need structural reform, but also people are suffering. And TJ has many examples where delay in delivering reparations leaves victims waiting for decades, dealing with escalating forms of harm, and ultimately eroding trust in justice institutions. And so climate reparations are likely to face those similar pitfalls. It's going to be aggravated by the phenomenon of the slow violence of the climate injustice. And so there's lessons both in good and bad practice in how do you grapple with the need to repair acute moments of harm with long-term structural changes. And then finally on this slide, I think we can learn from TJ regarding the importance of moving away from voluntary contribution models. That of the reasons for us having a primary voluntary contribution model at the moment completely makes sense from a political perspective. But we need to, at some point, I think, move away from that if we're going to take redress seriously. So the failure of the International Criminal Court, for example, to deliver reparations on the ground shows that you can make even judicially enforceable orders that lead to nothing if you haven't taken practical steps to explore the funding models. So those are kind of big picture lessons I think can be learned for TJ. For just the last couple of minutes, I want to highlight these new directions that I think are interesting from a climate reparation perspective. So the first is the case of Colombia, where the jurisdiction of Special Para La Paz has recognized various territories of Indigenous communities, Black communities, of being victims of the Colombian conflict in their own right. So this offers acknowledgement that landscapes, ecosystems, but also the relationships that exist between humans and the other than human world can suffer, and that suffering can require a collective response. And so they are now beginning to bring out reparative sanctions that seek to redress the harm perpetrated against territory. So I think this is really interesting for future climate litigation because it offers an example of recognizing reparative frameworks that treat ecosystems as rights-bearing entities. So it draws on rights of nature practice, and it's not a coincidence that Colombia is also a place where rights of nature is being pursued outside the conflict context. So the HEP resolutions really enforce the argument that natural entities can have both material and cultural and spiritual significance, and therefore reparations need to take those various levels of harm seriously. It's also an example of the innovation that becomes possible when you really take Indigenous worldviews and approaches to harm and justice seriously, which I think potentially offers lessons for Australia in any future attempt to redress climate harms domestically. And then finally, I wanted to acknowledge the debates around ecocide, because a lot of the discussion around ecocide focuses on deterrence. But I don't really think having a crime of ecocide is going to offer that much deterrence, just because of the way international crime operates and the limitations on international crime as a stick to hit people with. But I do want to highlight that if, and I think it is now a case of when rather than if, ecocide is added to the International Criminal Court's jurisdiction, while there are huge challenges, it won't apply retroactively. So we're not going to be able to put, fossil fuel CEOs on trial for things they did in the past. There's obviously political barriers. States would have to ratify the amendment, even those that are already state parties. And we're also obviously living in a time where the legitimacy of the entire ICL model is in doubt. But putting those to the side for a second, the ICC is interesting exactly for its ability to incorporate victims' perspectives and to incorporate reparations. So I think even with those challenges, I'm not trying to make light of them, there's a possibility here for victims of ecocide and acts that contribute to the climate crisis to participate, to be heard, and to campaign for reparative measures. And I think what's also interesting is if we have a crime of ecocide that's used to prosecute acts that contribute to the climate crisis, then we are also moving towards some aspect of individual liability as well as state liability. So, for example, if we have a CEO of a fossil fuel corporation convicted of ecocide, these are potentially very wealthy individuals. The ICC could require them to make contributions to fund reforestation programs, to do land restoration efforts, to offer compensation to communities, which is a significant shift from the current climate finance approach, which is fragmented, dependent on political will. So the ICC has a trust fund for victims that already facilitates reparation projects. As I say, that has faced challenges around funding, but some of those have already involved eco-sensitive forms of reparation that seek to respond to environmental harm, even in the absence of a direct prosecution for an environmental crime. And the trust fund facilitates a range of other forms of victim assistance, even in the absence of a judicial ruling. This is currently voluntary contribution funded. But as I say, ecocide offers the possibility of going after wealthy individuals with a particularly high level of individual responsibility for the crisis that we find ourselves in, and so offers some interesting future avenues. So, lessons to be learned. There are good and bad examples of practice that could usefully inform the climate reparations debate to be drawn from transitional justice. These include the absolute importance of genuine and meaningful victim participation, the need to understand reparations as something beyond monetary, as something that has symbolic dimensions, backward and forward-looking dimensions, and it really takes into account cultural and spiritual harms as well as material. And then the recognition for other than human victims and the push for ecocide signal emerging pathways towards justice. None of what I've said is a silver bullet, but I think, as I said earlier, the urgency of the situation requires swift adaptation across multiple legal pathways. And considering transitional justice's multiple decades of trying to grapple with large-scale harm, it's important to learn wherever we can. Thank you.